Inevitably, over the course of history, laws get passed that are in conflict with one another, which then creates space for the executive to go in and say, well, there are these two laws, they conflict, and my administration is going to follow this one. Under the Obama administration, the Secretary of Homeland Security issued a memo saying that there are certain cases that are low priority, we're not going to prosecute them simply because we have bigger fish to fry.
This is a temporary stopgap measure that lets us focus our resources wisely while giving a degree of relief and hope to talented, driven, patriotic young people.
It just depends on, if you're liberal, you tend to not like it when Republicans exercise prosecutorial discretion, and when you're conservative, you tend not to like when the Democrats are exercising prosecutorial discretion.
But there's nothing compassionate about the failure to enforce immigration laws. Enforcing the law saves lives.
Courts are hesitant to get involved in immigration policy decisions.
We are the immigrants! We are the immigrants! The mighty, mighty immigrants! The mighty, mighty immigrants!
And so the concern with a program like DACA or DAPA is that only 5% of applications get rejected. The Department of Homeland Security has standardized procedures, so it's really hard to make the argument that it's a case-by-case decision.
Simply put, if we are to further our goal of strengthening the constitutional order and the rule of law in America, the Department of Justice cannot defend this overreach.
There was no reference to any statutes, any provisions that give the executive the authority to do something or not, any legal language in the document itself. And so if you are arguing that the decision was not well reasoned, those are very, very good points. My suspicion is that's what the case will turn on, and if the Supreme Court gets involved, it'll be a procedural decision about whether the record itself was sufficient to justify the decision to rescind DACA.